Welcome to Court Helicopter Explainer, where we are dealing with the question of the late S.M. Otieno Burial versus Wamboi. We have given in the first episode several arguments, one by Wamboi and his lawyer, Senior Counsel Haminwa. We have given arguments of the Umira Kagere clan with their advocate Kwach, serious arguments. So the question now we are dealing with, what did the judge, Justice Bosire, giving his judgment, pronounce himself on that matter? Over 20 issues were raised before the judge, and these are the issues that the judge was required to deal with. How did the judge deal with this person? I go slowly by slowly. Justice Bosire says, it is pertinent to observe here that Kenya has not enacted any law with regard to burial of deceased persons, nor is there a statute of general application in England in that regard, which was in force by 12 August 1897. which could be by dint of Section 3(1) of the Judicature Act, Cap 8 laws of Kenya, be applied in Kenya. So the judge is appreciating that indeed there is no law present to deal with the question of burial. That was then. To date, Kenyans as we are, there is still no law. And I don't know what Parliament is dealing with. Everybody is going to die. Members of Parliament are going to die. The President will die one day. Why can't Parliament enact a law that deals with burial? Families suffer a lot. The family of S.M. Otieno and the family and the children suffered a lot because there was no law. Make it known to you that even if you die yourself, there is no law in Kenya to deal with this question. This is what the judge said. The judge proceeds and says, the issues which arise in this suit concern burial. The provisions of the Marriage Act deal with marriage and not burial. They do not therefore avail the plaintiff. So the Marriage Act does not deal with burial. So when you say you have been married, how will you be buried in that marriage? The Marriage Act provides for marriage and division and how you deal with the properties of your marriage. He moves on to say, he says, there is no issue in this case touching on the administration of the deceased estate. Even if it was there is the law of succession which has exhaustive provisions for that purpose. So the judge is saying, if you die, your property will be dealt with under the law of succession. But your body, how you'll be buried, there is no law that will deal with that. Is this not a serious question that Court Helicopter is bringing to you? In marriage, the law makes you get married. It also deals with the property in marriage, but it does not deal with your body when you are dead at burial. In succession, when you die, there is a law that deals with your properties when you are dead, but there is no law that deals with you when you're in the mortuary. Wow, amazing. Let's look at it. The judge says, I researched on English authorities based on the common law and which deal with burial, but was unable to find any, or nor were there and referred to me. Those I could find are based on the English law with regard to the administration of estates, which are irrelevant to this case. That then leaves us with only the personal law, which is in this case the customary law. In England, there was not even one case about burial. What does that tell you? Wazungus don't fight about burial. It is us Africans who are fighting over the burial. We did an episode about the president of Zambia. This is a serious dispute. Edgar Lungu, the family and the state cannot agree. So disputes of burial are African in nature. Why? Why are we so fixated about a dead body? Why do we lose our heads about a dead body? And the judge found out that there's no property in a dead body. That is not me. You can never take a dead body. For example, if a dead body borrows credit, you cannot detain a dead body in a hospital. We did that because the dead body has no property. You can sue the estate. You cannot hold a dead body and put it as a lien. But why are we so close and so intent on getting to fight over a dead body in burial? The judge says, I had earlier set out what the defendant said in the Luo customary law and traditions on burials. No evidence was called to challenge or contradict them on that score. I have no basis for finding otherwise. I accept, and the judge is saying, I accept as true what the defendants and their witnesses set out as the law customs and traditions with regard to burial. That then answers the fifth issue of the list of agreed issues. So the judge agreed with Kwach and the Omira Kagere that the procedure to bury a Luo is as pursuant to the customs of the Luo, and we did that in the first episode. The next issue the judge said I must grapple with is whether the deceased was subject to Luo customary law. This is the most fundamental issue. When you are married and you are a Meru to a Kisi, a Kamba to a Kikuyu, a Luo to a Mijikenda, a Horia to a Luya, are you subject to the burial law of your husband? This is where thunder from court helicopter is. Are you in an intermarriage between a tribe and another tribe? Are you subject to their law? Remember, for example, some tribes in Kenya, the body lives at mortuary, direct to the grave. In some customs, the body viewing is only done at the mortuary, while others, the viewing of the body is at home. In other customs, the body stays at home for 2 days or 3 nights or 1 night. While where you come from, the body does not get into home. The body leaves the mortuary direct to the grave. So the question is, when you come from a community where bodies are not viewed, bodies don't sleep at home, then your husband dies or you die, are you going to be subjected to those customs? The judge grappled with this, and he says, it was the plaintiff's contention and her counsel submission that he was not subject to law customs, having chosen to marry under the Marriage Act and having lived away from his ancestral land for a considerable length of time, and also because he had chosen a lifestyle and behavior which were in consonant with Christianity and Western civilization. So the lady is saying, me, I've never lived there. My children have never lived there. I was married under Marriage Act in church. I was married in the AG's office. Don't tell me to go there. What did the judge say? God, Vivian, get us an extinguisher, because this one, many will collapse. Ambulances be around, because now, what did the judge say? Oh my God. The plaintiff, however, that is the wife, that is the lady, seemed to contradict herself, because she admitted that that the deceased was a member, number 18, in a clan association whose aims and objectives have been and still are to help in the transportation and organization of funerals of members of Omira clan. A person totally divorced from customs and traditions of his clan or tribe will be slow, if not totally opposed, to becoming a member of an association whose aims and objectives totally conflict with his belief. Ladies, is your husband a member of these village clans in Nairobi meetings? Does he go to those meetings to transport people who die in Mombasa, to transport people who die in Nairobi? But he has told you he's not going to be subjected to customary practice. The judge moves on to say, furthermore, the deceased did attend at least 3 funeral ceremonies at his ancestral home. The first one was that of his father. He did attend his father's funeral, in which he observed the 4 days of mourning required by custom. When the man went home to bury his father, he stayed for 4 days, as per the Luo customs for mourning, within which time he abstained from coming into contact with his wife, as customs demand. Under the Luo customs, when your father has died, you do not have sex with your wife for 4 days. You abstain from coming into contact with your wife. Has your husband ever done that? But he is lying to you that he is not a traditionalist. 3, the judge said he also spent 4 nights outside as required by custom. For 4 nights, he stayed outside. This is a senior lawyer, a man with serious properties in Langata, but he stayed outside. Has your husband stayed outside? Can you stay, you the lady from another region, staying outside for 4 days? And you have a mansionette, you have a bed, you have the best house? That is customs. The judge moves further. The second funeral was that of his nephew George Michael Oyugi, which took place in 1983. The third one was that of his elder brother Simon Odhiambo in 1985. Wamboi admitted that the deceased was immensely involved in all those funerals, which was in line with the Luo customs. As rightly pointed out by Mr. Kwach, he assumed the role of a head of the wider family after Simon's death. It is in evidence that he sent money to Simon's 2 widows to help in repairing the roofs of their respective houses. That is in line with the Luo customs that as a head of the family, the deceased was under duty to help those widows. Has your husband ever supported the widows of his brothers? Has he sent money to the village to deal with funeral expenses? My sister, when if you are arguing before a court that your husband is modern and Christian, M-Pesa statement itakukaranga mbaya. We men send every day funeral contributions to the village without telling our wives. The judge is moving on. There's one other aspect. Wamboi admitted she typed the minutes of a meeting held in the deceased's office on 4th May 1981. In the document, one of the matters agreed upon between the deceased, that is the Wakili, and his late brother Simon, and the first defendant, was that the deceased and the first defendant would inherit from their father, Jairo. Then the deceased, parcel number Central, Lego Nyalgunga 1983. Neither the deceased nor the first defendant had the legal right, except under Luo customary law, to claim an interest in that parcel of land. The deceased's claim over that land was based on custom. S.M. Otieno claimed land of his father. Wamboi agreed his husband to claim land of his father, how then can you say your husband was never part and parcel of the Luo custom? You listening to Court Helicopter, is your husband having a parcel of land in his ancestral land? Then he tells you he is not. Why? That's a lie. The courts have found out. If he owns land from his father's land, then my friend, that man is bound by the Luo customary law. Finally, as recently as November 1985, the deceased did pay dowry for his son's wife. Upon what basis was dowry paid? The deceased was complying with an age-long custom that dowry must be paid to cement the relationship between the family of the bride and that of the bridegroom. Wambui did argue that because dowry was not paid by the deceased to her parents, then he did not consider himself to be bound by Luo customs. The deceased may have not paid dowry, but the fact that he did not do so did not in itself without more preclude him from being subject to other customs like those with regard to burial. As has been shown above, the deceased did demonstrate that he did espouse certain Luo customs pertaining to matters other than his marriage with the plaintiff. I'll therefore answer the sixth issue in the affirmative. Haminwa's argument, senior counsel. Hamin has not been senior because of today. He has been senior in his argument. Let us see how the judge evaluated senior counsel Haminwa's view. The theme of submissions by Mr. Haminwa, learned counsel for the plaintiff, concerning Luo customs and traditions in general, is that the Luo customs are outmoded, obsolete, and out of step with Christianity and civilization. That is submissions of Haminwa. Whether you agree with him or not, those are instructions of his client. We don't generate arguments. Haminwa was told to tell the court that the Luo customs are outmoded, obsolete, and out of step with Christianity and civilization. It was his view that of his client that they were unacceptable to the plaintiff, for among other reasons that she had come from a different tribe. She was not Luo. She had come from a different tribe. Also, that she had adopted a lifestyle which was incompatible with those customs and traditions. She wore a miniskirt. She wore lipstick. She wore calcit. She wore nails. She's a modern lady. How do you take that lady to the village? Honestly, a digital lady, a Gen Z of 2026 to go to the village? That is Haminwa's argument. Let us hear what the judge said. What did the judge say? To that, I say this. My friend, this is killer. Bosire the judge should be recalled to be tried, whether he had a personal hatred, but this is the judgment. He said, the plaintiff, a Kikuyu by birth, chose to be married by a man who was not of her tribe. She knew she was marrying a Luo. He at no time, at least according to the evidence, renounced his tribe or declared that apart from marriage he would not be bound or be subject to a customary law where its application is permissible and is not in conflict with a written law or repugnant to justice and morality. Nowhere did the husband of Wambui renounce him being a Luo. His name remained S.M. Otieno. Otieno is Luo. Did he change to be called another 2 English names. That is what the judge is saying. He moves on to say, no condition has been shown to have attached to their contract that apart from their marriage, he would not be subject to his customary laws and traditions. Here the judge, the killer punch. She chose to be married by the deceased. You have chosen to be married by that person. A Luo by birth. Knowing him to be such, she knew he was Luo by birth. You know your husband is Luo, is Kisi, is Luya, is Meru, is Mijikenda before you say I do. Are you today learning that your husband is Luo? That's what the judge is asking Dr. Hamino. Very, very bad. She had seen him participate in burial ceremonies which were customary or potentially customary in nature. Although evidence was laid that the ceremonies were a blend of Christian and customary rites, she cannot now complain that the Umira Kagere people are uncivilized or have a lifestyle quite different from her concept of civilization, because they did not at all force her to be married into their clan. So the question the judge is asking, who forced you to be married into that clan? You knew Omari is a Kisi. You have married Omari. Who forced you? Subarus have not come to you. The DCI has not blown a gun to force you. We did the concept of the dancing queen, and we brought the question that volensi non fit injuria. If you decide to join the Luos as a wife, you are bound by their customs. If you decide to join the Kisis as their wife, you are bound to be part of that family. That is the law. The judge is saying, what? Do we take water? I think it is hot here. Let me take a glass of water. The judge is lethal. The judge proceeds. Even in Western countries, everybody talks of civilization. The judge went to Europe, which Mr. Hamino and his clan considered to be civilized. The position has been and still is that where, for instance, an English woman domiciled in England marries a man of a polygamous race in his homeland, knowing that she is entering into a marriage that is potentially polygamous, the validity of that marriage depends on the personal law of the husband and not on the personal law of the wife. If he is in his own country, he takes to himself another wife. The English wife cannot complain. What? So the judge is saying English law. When an English woman marries a Kenyan, when Obama's mother married Obama's father, a Luo, she knew very well Obama's father will have several wives. That is why Obama has very many mothers. So the judge is saying, don't cry. Even the English law, if you marry a man, you bring him here in Kenya, and the law applicable is the law of the man, not the law applicable of the woman. This is the decision in Britain. Oh my God. That is the case of Kenward versus Kenward. It's a 1950 to all AR 295 at page 310. This as per Lord Denning. Any lawyer who hears Lord Denning removes the cape and say, Lord Denning is a judge. May Lord rest his soul in eternal peace. Lord Denning giving that judgment. Justice Bosire moves on to say, the case I have cited above deals with conflict of laws in marriages, but does illustrate the point I'm trying to make. It is the woman, that is the plaintiff, who made the choice, Wamboi. She should not complain when she finds that certain customs upon which certain rights and duties are based are incompatible with our concept of civilized living. She can only complain if the customs do not meet the test of Section 3(2) of the Judicature Act. The judge went ahead. I wish also to observe here that we are not concerned in this case with whether or not the customs and traditions of the Luo are acceptable to her. Rather, the issue is whether or not the deceased, the husband, was subject to them. It is immaterial what the plaintiff thinks about the Luo customs, whether they don't please her. The question before the court is, was the late senior counsel S.M. Otieno subject to Luo customs? Yes. What the wife feels, what the widow feels is immaterial. That is what the judge is saying. He moves on to say, the issue which I must now grapple with is whether the Luo customs and traditions set out earlier with regard to burial are repugnant to justice and morality or public policy. He moves on to say, she testified that a widow is compelled to sleep overnight in the same room with the body of her deceased husband, together with a Janeko. Janeko, into bracket, a lunatic or a drug addict, as she described him. Then she would then be compelled to shave her head and also the heads of the children of her marriage with the deceased husband. Wamboi told the court, under Luo customary law, a widow, as I said, under the Luo customs, a body must sleep in his house overnight. A widow must sleep there. This is according to her. I know this is a very scaring to young Gen Zs and very many women who do not know different customs of different religions, of different tribes. The lady, the widow, must stay there overnight in the company of a Janeko. A Janeko is a madman or a drug peddler. Wow. 2, after this, she must be shaved. Her children must be shaved. Gen Z, are you going to be shaved? The girls. It is not the boys. All the children will be shaved. Both the girls and the boys. Your mother will be shaved. You'll also be shaved. Whether you are a boy or you are a girl. Are you going to remove your dreadlocks? They must be shaved. Your culkit must be shaved. This is Wamboi telling the court, I will not go to sleep in a house with a body, with a wazimu, and also to be shaved. She further said that the widow would also be compelled to enter into a levirate union with a man chosen by the clan. A levirate marriage. They call it, and you call it, inheritance. It is not inheritance. It is called levirate. We did a search to understand this levirate marriage. Can you refuse like you are boy? Yes. There are incidents in the Bible when women refused to be levirate marriages or to be inherited. It says, it is called chalitza. If the brother-in-law refused, the widow would perform a ceremony known as chalitza, involving removing the brother's shoes and spitting in front of him to signify the breaking of the obligation according to the law. So, this is biblical. If the woman refused biblically, she would remove the shoe of the brother who is alive, spit inside, while the man is looking to say, I have rejected you. I don't need a child. So the judge moves further and puts it this way. She further said that the widow would also be compelled to enter into a levirate union with a man chosen by the clan. She did, however, confirm that she has not seen that happen, more particularly in the ancestral home of S.M. Otieno. The defendants and their witnesses admitted that if a widow is still of childbearing age and has desire to have more children, she may elect to enter into a levirate union with a man of her choice. There is no compulsion involved. Support for rendered to their contention by the fact that the widows of S.M. Odhiambo, the elder brother of the deceased, have not to date entered into a levirate union, even though they may still be of childbearing age. It is the evidence also that there is no requirement by the customs that a widow sleeps in a room with the body of her deceased husband together with her janeko. So the court found out that it is not true. It is not compulsory. Number two, the judge found out that it is also evidence that the shaving of hair is not obligatory. It's not mandatory for you to be shaved hair. The judge says, I find no law with which the customs conflict and find nothing to make me hold that they are repugnant to morality. The fear of supernatural consequences by those governed by them will not per se make the customs repugnant to justice and morality, nor can that be said about the observance to Tereburu. You saw Tereburu when Raila Odinga was dancing. Joey, 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 the Tereburu is here. It's a ceremony of running with the animals a day after burial ceremony. It is symbolic of sending away evil spirits or sitting around Magenga. So the lady is saying the Tereburu we saw, the cows that were taken by everybody to Raila Baba Amolo Odinga's grave. People dancing. Tereburu, Joey, Joey, Joey to Wamboi. That is uncivilization. What did the judge say? Very interesting. It was stated that it is customary during the period of mourning for men to spend the nights outside, warming around Magenga, Moto. It is logical to have a fire because nights, from what we know, can be cold. So it is scientific. The men are here mourning. The women are inside. There must be fire. To her, that fire is demonic. That is the devil's fire. To the judge, he said the fire is scientific to warm. In Luo Nyanza, the nights are cold. The rains are a lot. Magenga, the fire must be present. Mr. Kaminwa stood up, senior counsel, and brought the issue of discrimination of women. He argued and brought about that this woman is being discriminated because she's a woman. Remember, under the old constitution, today we have very explicit constitutional provisions bringing Article 27, equality of everybody and non-discrimination because of gender. What did Aminwa say? And what did the judge say? Mr. Aminwa put forward a formidable argument in support of equal rights and opportunities for women. And he oftentimes expressed support for feministic causes. It was his view that by the Luo customs, excluding women from decision-making forums as to where their deceased husband would be buried amounts to discrimination against sex, and that offends the provisions of Section 82 of the Constitution that time. The judge says that with due respect to learned counsel, he says that Section 1 shall not apply to any law so far as that law makes provisions with respect to adoption, marriage, divorce, burial, devolution of property on earth, or other matters. So the law was not against law customs. Hamino went further and talked about the property. And he brought cases, Karanja versus Karanja. The judge said that case deal with property. A corpse does not fall into the category of property. For the foregoing reasons, I hold that the Luo customs pertaining to burial are neither repugnant to justice and morality, nor are they discriminatory as alleged. The judge listened to the children. Jairus Michael Otieno, who was a student at William Patterson College, New Jersey, in the United States of America, and his brother, Patrick Louis Wilson Oyugi Otieno, formerly a student at Green State School in the Rift Valley. Both testified to the effect that their father, the deceased in this case, had more than one occasion expressed to them, respectively, and at different times, the wish that in the event of his death, he be buried at either Langata or Matasia. These are the children saying they're in school. They also opposed the deceased being taken to Nyalgunga for burial with some degree, and the judge underscored this. The children opposed their father going with some degree of arrogancy and contempt for the Omira clan people. They stated respectively that they are different from them. The children said, we are different from these people, and referred to them as being, oh my God, lazy, primitive, and people who had a lifestyle of uncivilized people. Those are your uncles. Those are your aunties. Those are your ancestors. The Gen Zs. The Gen Z children of SM said the Luo people are lazy, primitive, and people who had a lifestyle of uncivilized people. They also said that they speak a different language. Omari speaks the Old English. My Gen Z friends, Vivian, my Gen Z friends, Bramwell, they twang. That is, they speak different language. Do you speak a different language and you think your parents are stupid? Just because you speak in whatever they call, I'll ask Vivian to tell me what the young people, their slang, their language they speak. Is that reason to call those who speak proper Swahili to be lazy? Is that reason enough to call Akinomali who speak the common English language foolish? The answer the judge found out. So the Nyalgunga clan is saying, come bury your husband, come bury your father, go back to Langata, go back to Matasia, go back to UK, go back to Netherlands, go back to Germany. In his final submission, Mr. Kwach, learned counsel for both the defendants, expressed disgust, rightly. So in my view, at the stand taken during the hearing of the case by the plaintiff, Jairus and Patrick, the mother and the children, they all unashamedly declared that should this court direct that the deceased be taken to Nyalgunga for burial, they will not at all attend. The plaintiff appears to have influenced her two sons. That's the judge saying. Because they said they had held a meeting as a family and together resolved to boycott the deceased's funeral if it is declared that he be taken to Nyalgunga for burial. They made a meeting as the mother, the widow, and the children said, if that is taken to be buried there, we will not attend. What did the judge say? That clearly demonstrated how far the plaintiff is prepared to go to ensure that things happen in, and I put in quotes as he puts, my way or never, end of quote. My way or never, end of quote. Open of quote. My way or never, end of quote. How did she expect me to believe her and her two sons upon the adoption of such a stand? To my mind as a judge, a litigant is only required to call evidence in support of his case and leave the matter to the court to decide in his favor or otherwise. Utterances which amount to implied threats are uncalled for, irrelevant, and border on contempt of the court. They offer no assistance to any litigant. Have you ever gone to court threatening the court that if the court makes this decision, you will not attend a burial? The judge found out that threatening a court is contempt, and it will never help you. You don't understand why advocates will always be saying, my lord, my lady, my ladyship, my prayer, with my kind permission. That is why, if you antagonize the court the way Haminwa and his party antagonized the court, considering all the evidence in its totality, the deceased did express his wishes as to where he should be buried, and he did so at Nyamila village, Nyalgunga sublocation, Central Lego location, Siaya district, to Albert Ongango on the day of the grave of Simon Odhiambo was being cremated, cemented. 2. Secondly, that according to Luo customary law, in absence of exceptional circumstances, a man has to be buried in his father's homestead at a place to be determined by the clan elders, if he had not at the time of his death established a home, accordance with the customs of the traditions of the law. Third, that although the deceased had established a matrimonial home in the common law sense at Langata in Nairobi, he had expressed a wish to Ongango to be buried at Nyalgunga. Fourthly, that our Luo customary laws with regard to burial, as propounded to me, were not repugnant to justice and morality and do not conflict with any written law. Fifth, that the deceased was subject to Luo customary law at the time of his death. The only other question which, apart from cost, I must now deal with, and which forms the crux of the remaining issues, is to whom does the duty of burying the body of the deceased lie? The judge made the following. To my mind, it will be idle to say that the clan takes a decision as to where and how a deceased person is to be buried. I formed the following impression. In each family, there is a person who is regarded as the head of that family. He takes the major decisions and may call upon certain elders to help him in resolving certain complicated issues. He decides whom to call and on what matters. the persons he calls will be of assistance to him. That appears to be what happened during the burials of the others. There is, for example, the shaving of the hair. These days, only a few hairs may be cut, or not at all. Shaving of hair appears to be considered not to be a crucial aspect of the customs. All I'm trying to demonstrate is that the decision as to the place and manner of burial is essentially taken by the head of the family, with the assistance of other responsible family members. The judge made the final orders. I am satisfied on a balance of probabilities that the Luo customary laws relating to burial do not expressly exclude women on matters pertaining to the decisions as to the place of burial of a deceased person. Particularly, they have distinguished themselves either in their respective families from which they come or the clan generally. It is my judgment, and so declare, that the first defendant and also the plaintiff have the right under Luo customary law to bury the deceased and to decide where the burial is to take place. However, because the two have shown that they cannot now agree on that issue, it is desirable and indeed imperative in the circumstances of this case for this court to intervene and direct as to the deceased place of burial. The justice of this case demands that this court directs as to where the deceased Silvano, Melea, Otieno, Senior Counsel is to be buried. Having regard to the Luo customary law relating to burial, which, as indicated earlier, is the law applicable in this matter, and considering the finding I earlier made that the deceased had expressed the wish that upon his death he be buried in Nyalgunga, I hereby direct and order that the deceased's body be handed over to Joash Ocheng Ougo and Virginia Edith Wamboi Otieno jointly, or to any one of them for burial at Nyamila village, Nyalgunga sublocation, Siaya district. That is, however, subject to them obtaining any necessary permits or transport to bury the body. That was the decision of the judge. So the question that we are asking, now that you have now known where you're married, this was a decision that was done in the year 13 February 1987. This weekend, we shall be looking at other decisions after 1987 up to the last decision from the Court of Appeal that gives landmark decisions. Keep watching Wakili Dan Sanomari. Always a pleasure to bring you the episode of burial disputes in Kenya. Thank you.